What's your take on the, the ruling yesterday?
Yeah, thank you very much, Willie, and the viewers. I think number one, yesterday was an historic event where for the first time in the history of Uganda, and perhaps even a domestic court for an international tribunal or domestic court using international best practice and international law, was able to come out with a verdict that there's need for reparations. And what was more significant was that also for the first time in the history of Uganda, and even perhaps a domestic jurisdiction, where government is made responsible, not liable, but responsible for paying for reparations for victims of war. And in this case, the court was very kind and accepted our request and prayers, where they ordered for at least 10 million shillings to be paid for persons who died, each person who has died in this case location, like 5 million shillings for sexual gender-based crimes, 4 million shillings for injuries, 3 million shillings for exhumation of bodies and decent burials, and then 3.5 million for property destroyed. So that, in our view, was a very good milestone, and we're really happy with the team, especially myself, Counsel Jane Amoti and Counsel McKay Robert, who are all victims counsel, and it's the first time in the history of Uganda where we had victims counsel, and I'm so proud of being part of that historic event.
Yeah, Counsel, do you see this as a country journey to what refers to justice and reconciliation?
I think so, but prosecution is just only one part of the puzzle. I think there's more to do that. We still have the amnesty, some aspects of amnesty can still be given. We still have other aspects of traditional justice. We still have other aspects of reconciliation, as they say. But this is one aspect of transitional justice, which is part of prosecution. But that cannot answer all the questions. Now, what is left for us is whether or not the family of Kwoyelo acknowledges that Kwoyelo actually committed the crimes. Two, whether Kwoyelo himself acknowledges. He says he wants to appeal, but in the end, if the appeal is over and he doesn't win, will he come back and say, I want to put or drink the bitter herb or reconcile with the community? So that's another step which is going to happen. So I think it's a positive step in terms of getting justice and reconciliation through prosecutions where people are held accountable and fighting impunity. Yes, to some extent, yes.
Yeah, rather than financial compensation for the victim, what about the issue of question of accountability in this country? Does this ruling also signify anything related
yes,
to that?
Yes, there is accountability, but also we must have both sides accountable. I know EPDF has to punish their people, but I think there's still a call so much for crime that took place maybe before 2001, before the ICC, before the ICD started prosecuting. So I think it's important. And somebody told me that even now the ICD might even prosecute Kony for other cases which are outside the ICD mandate. So I think there's going to be a lot to watch as time goes on.
Okay. Now, you're looking at the breakdown, as you stated, from 10 million down to 3.5 as being the smallest unit. I've seen you only submitted a list of 103 as victim that already being accredited, the victim status. Would that money be enough?
No, I think there's a bit of a mistake. I saw it in the media report. The 103 were what they call dual status victims. They are dual status because they are witnesses and victims at the same time. Those are 103 who are in court. And I said yesterday on radio that they are like the low-hanging fruits. They are already in court, admitted. Then the court also estimated that during our application we had about 5,400 people as an estimate. But the court also opened it up that there are more potential victims who might come in. That's why they gave a period of 360 days for anybody who feels they are in the geographical area, which is Pabo and Mogi sub-counties, and then also in the temporal jurisdiction in terms of time, 1996 to about 2006, where Kwoyelo was convicted for having committed this crime. So the number, right now we have 103 who are dual status, the double victim witness, and then we also have 5,400, an approximate size which we use in our application. But we said, look, let it be on a rolling basis where we're given 1 year or 360 days to starting yesterday to bring the application. I already even warned the victims committee that look, the 1 year might look very long, a long time, but we're all busy people and time will end up. So we wanted to have a target by February, March. All applications must be within the court for have the registrar to look at it, and then she'll forward it to the trial panel.
Okay.
Yes.
Okay. Now, how are we going to do that? Because looking at, do you have team that will work in this case scenario where they gather data and
yes. Even I was privileged to have been the person who nominated all the persons who work for the ICC to fill the forms. I vetted them and gave them to the ICC to interview them. So I've been using that team as well, who did the forms for the victims for ICC. I've been using them. Most of them are now lawyers, but then there were young law students. Now I use them plus other team members. So we're going to have a team, even experts. As yesterday, I was talking to different experts to help us achieve that target. So we're going to have the standard form we have, which with time I can share with you. They're almost based on the model on the ICC forms, perspective form, but with a bit of modification to suit our Ugandan context. So
yeah, thank you, counsel.
Yes.
Now, as we go to the end, I've seen court did not take any, declined himself to establish victim trust fund, or it does not even mandate government to come out with a annual budget for this reparation.
Do you
think we shall be able to realize this?
No, but you see, the court was very wise. I think we also threw it to them, as a lawyer, throw it to them and make sure they see what happens. Number one, the court says, yes, this is more of like, they call it the political doctrine question, where courts are not supposed to interfere with political work of government or the parliament or executive, but they say they must take key notes on that. That look, whereas we cannot order government to do that, we take note that is a very important point. That's not a tool for advocacy. Even yesterday I spoke to some different NGOs and CSOs, international NGOs, to start doing advocacy work, to have that kind of fund available. So I think the court was careful not to order, but said, look, I take note on this. And once the court makes that ruling, you can take it up as an activist group to say, look, this must be done. We need this and this, yes. Because the TJ policy, for example. So now we have to push it to Parliament and say, look, this was there. The TJ policy court even noted that this is, we may not order you now, but this is something which is worth a notice. So I think we have somehow achieved now, because it's in the court order now. I mean, in terms of court observation, not an order per se, but the court notes that they made a sort of declaration that is a very important aspect of our processes. Yes.
Yeah, finally, we have seen lack of legal framework has complicated the cattle compensation.
Yes.
Like as we talk now, the reparation policy in Uganda is not there.
Yes.
Don't you think government may, based on this thing, there's no law that will compel them to compensate people who have lost their life, people who got injuries in this case of court ruling?
Yeah, but see, there are two arguments. The Attorney General is saying, look, we have been giving expression payment. The court says, yes, you have been giving people on what basis? So you have a framework, at least for these victims, have a framework so far, but that's why you need a law. So you can come, don't deny victims reparations or some kind of help because there's no law. Don't hide under that fact. So that's why the court said, look, you have been giving money, 5 million, 10 million in Chitezi, 5 million in this July bombings, you know. There's some framework, so you must do it. The state practice has been that at least money is given to victims. So they're saying, look, establish a system where you're going to be paying. So for the law is the futuristic thing. For the future, yes. But as we speak now, the court has said, look, give them something and make sure you implement some of these things that have been given out. So they have appealed it. We're going to wait for the appeal, but it's good. Okay, maybe the Court of Appeal will perhaps confirm what the law panel says in terms of the orders that they made and the recommendation they made.
Yeah, counsel, with two rulings in the ICC, International Criminal Court in The Hague, and here at the International Crime Division, High Court. How urgent do you think the need for having a reparation policy in this country, especially for the war victim in this country?
Yeah, I really feel sad that I don't have much to say in terms of my power. But if I, for example, I was in Parliament, I would have maybe, I don't perhaps brought some. I was part of the group which drafted sort of like a petition to Parliament, where we gave it to Honorable Father Nen to present. I was number 2 actually in the petition, which I can share with you about the need for this kind of policy. So that's why it's important, it's urgent. We need this thing yesterday. That's why we need to have this policy in place to be able to have the policy in place. Yes.
Anything you want to add on this ruling?
I think we must all be alert. I thank the media so much because they are really interested in this topic, and you must keep on in the list of people arguments for and against, so that you can develop something good, develop good jurisprudence, develop good arguments in this respect.
Okay, thank you very much.
Yes.